Dan's done a video already about the Prince Harry case. You may have seen that he's got a claim against a newspaper. There was a hearing where part of the claim wasn't allowed to go forward, but some of the other aspects are. And that was done under a procedure called summary judgment. So I thought it might be quite useful to actually chat about what summary judgment is, and also a related thing called strikeout, because these actually crop up a lot in just everyday, regular litigation. And they're quite useful, especially in low-value claims, in like what we call small claims tract claims. Because if that goes to trial, there's a weird thing that each side picks up their own costs. But if you can get a case struck out or win on summary judgment before the trial, you can actually argue that you should get your costs. So, that's a little tactical thing there. But what essentially is it? Well, okay, let's say somebody issues a claim and you file a defence. Now, normally, you go through all sort of disclosure and exchanging material and witness statements, and then it goes for trial. But what if you say, well, hang on a second, we don't need a trial and all the expense on this, because we can see from the start that either the claim or the defence is rubbish. And there are two grounds for that. Let's say that the claim is just deficient somehow legally. So to give an example from defamation, because that's something I'm familiar with. In defamation, you actually have to set out the words complained of. You actually have to quote them. And obviously, if you go to sort of defamation lawyers, they usually get that right. But if you do it yourself, you see these where people say stuff like, oh, and he was saying all bad things about me and calling me a crook and saying all disparaging things. It's like, yeah, but what? What exactly was that person saying? So it's actually in one of the practice directions you have to set out the words. But so let's say somebody doesn't, and they file a claim and they haven't sort of ticked all the boxes. Well, even before you file a defence, you can apply to strike out the claim. You can say, well, this claim is deficient as a matter of law, so it stops here. And quite often there's a hearing. Sometimes judges will do it on the papers. If judges ever do, though, make a decision without a hearing, the losing party has 10 days to say, no, I want to have my say in court. I mean, sometimes, the judgment's so detailed, you go, well, there's no point. You can see what's going to happen. But you can have a hearing. And if you can successfully say, well, this claim, just is deficient, it will be struck out. Now, what quite often happens where there is a strike application, sometimes you say, well, actually, I do have a good claim here, I've just said it wrong. So can I have permission to amend my pleadings? That's the particulars of claim, to actually do it correctly. Usually that will be allowed, although you'll have to pay the sort of costs so far because they've all been wasted effectively because you didn't get it right. If it is struck out completely, theoretically, as long as you're within limitations still, you can reissue a fresh claim and try to get it right that time. Usually, though, there's a requirement that, say, for instance, costs have been awarded against you in the strikeout application, unless and until you pay those, you won't be allowed to proceed with your fresh claim. But this can also be the same with a defence. Say, for instance, you file a perfectly good claim, contract claim, I did this work, he hasn't paid me, and then he sounds, yeah, but there was that time when, he did something else, or he did, something, he ran over my dog or something. Say, well, that's all very interesting, but, that's not a defence to this claim. Now, the fact that you have actually another claim against that person, even if it is unrelated, you can bring that as a counterclaim, and or you can ask for what we call a set-off, where it's basically, yes, I do owe him the £10,000 for him building my kitchen extension, but then he did I'll say crashed into the car because I don't like dogs-related stuff, and that cost £10,000 worth of damage, so that should cancel it out. That's a set-off. And the good thing about set-offs is you can actually plead them as part of a defence, so you don't have to pay an issue fee. If, however, you say, well, actually, yeah, I owe him £10,000, but he crashed into my car and caused £20,000 worth of damage, then because you're actually asking for more, that's a counterclaim, and you have to pay the fee for the counterclaim. So that's why we quite often just plead set-offs. So that's a strikeout. But what's summary judgment? Well, summary judgment is, okay, legally they've got everything right. They've ticked all the boxes. However, on the facts, even if you accept everything they say is true, their claims still can't succeed. They haven't, again, to say defamation, they haven't shown that they've suffered a loss, factually or something like that. Or, in a contract claim, it's like, well, yeah, or a negligence claim. Let's say a negligence claim. Yes, they've shown they were negligent. They've shown we were negligent, but they can't show that they suffered a consequential loss. So factually, their claim can't succeed. And the same, you might say, well, we've put a claim in, they filed a defence, but even if everything they say is true, that doesn't amount to a defence. Well, you can go for summary judgment. Now, the thing with summary judgment is the party that is seeking summary judgment, for the purposes of the exercise, you agree to assume that everything else the other side says is true. Now, that's not an admission that can be held against you later on, but just for the purposes of the summary judgment application, they will say, right, let's assume everything you say is true. Now, judges aren't supposed to conduct a mini trial; they just literally do it on the statements. But they are allowed to take into account stuff like inherent implausibility or inconsistency between statements and things like that. But yeah, that's a summary judgment application. And like I say, you get summary judgment, which is usually the claimant saying, our claim's brilliant, their defence is rubbish, we should just win now without a trial. Or sometimes it's called reverse summary judgment, where the defendant says, actually, now we filed our defence, it's so brilliant that their claim can't succeed. Obviously, there's a little degree of overlap between those two, and you have to be very careful. There's a great appeal judgment that begins, such and such party were successful, succeeded on summary judgment. Unfortunately, they've actually applied for a strikeout, so we're going to have to allow this appeal and go back and do it all again. Because you can only, actually run the, if you apply for summary judgment, you have to do summary judgment. If you apply for a strikeout, you have to do a strikeout. Usually, to cover yourself, you will apply for summary judgment and stroke or a strikeout. And also, as what happened in the Harry case, it doesn't have to be all or nothing with a claim or a defence. You can seek to strike out or obtain summary judgment just on part of the case. So, and judges quite like these exercises because it, trims the wheat from the chaff, and it means that you're only going ahead and having all the expense of calling witnesses and having days in court on a full trial on the issues that are A, genuinely in dispute, and B, one side, both sides have a punt on. Because, like I say, if it's a situation where it's really obvious early on that one side or the other is going to succeed, then why waste the time? So that's what happened with Harry, and like I say, it's a really common thing. So remember that, and like I say, there is that cost advantage thing in small claims. Anyway, as always, if you did enjoy that, please consider clicking the like button and also subscribing.